Okay, so we'll go ahead and get started. Hello, happy Friday. Welcome to our Assisted Outpatient Treatment Community of Practice. Thank you all so much for coming. If you received our email reminder, you know that today we're talking about risk management across the AOT system of care. So I'm glad you could all join us because this is going to be an important conversation about understanding and mitigating risk when working with the assisted outpatient treatment population. So, as many of us know, AOT work sits right at the intersection of behavioral health and law enforcement and the broader community. So, each of those systems brings its own perspective on what risk looks like and how it can be reduced in ways to keep clients, providers, and communities safe. So, today we've brought together a great group of professionals who live and breathe this work from different angles. We have Tom, who's a senior risk control consultant representing the insurance perspective. We have Christy from Clinton Eaton Ingham Community Mental Health. And we have Scott Smith here to talk about the clinical side of things and facilitate the conversation. So, just so everyone knows, it's not our goal today to give legal advice. That's not what this is about. We're here to have an open, practical conversation about how risk shows up in AOT work and what we can do across systems to help mitigate it. So I just want to make that clear. We don't have, a lawyer here to weigh in on that way. So none of this is legal advice. But that, doesn't have to stagger our conversation and our dialogue. So, just a quick note before we get started that the opinions and views shared today by our individual professionals don't necessarily reflect the Center for Behavioral Health and Justice's views or Wayne State University's views. So, just that little disclaimer there. And by the end of the session, we hope that you'll leave with a better sense of how different partners think about risk and a few concrete strategies or takeaways you can bring back to your own work. So, as always, before we start, I got to plug those Q&A sessions. So twice a month, we have Dr. Scott Smith available for office hours to ask any AOT related questions. We're going to go ahead and drop that information in the chat. But yeah, twice a month, Scott's available to answer questions. It's also a good resource to give natural supports. We've done a lot of help with folks, loved ones of, people on AOTs as well. So that is also a resource for that. And, if in the meantime, if you have questions that can't wait until those office hours, you're always welcome to reach out to us with any AOT related question as well. So if you don't have my email, I will also drop that in the chat. Yeah, so I will also drop those dates for the Q&A. So before we start our main discussion, I'm going to have our guests introduce themselves, and then I'll kick it over to Scott to facilitate this conversation about risk. So Scott, why don't you go first and do a little introduction?
Thanks so much, Olivia. Happy Friday, everyone. Scott Smith here, technical consultant at the Centers for Behavioral Health and Justice. I've gotten to know many of you over the scope of our time together with the FSI initiative, and it's good to see such a great turnout this morning. Christy?
Morning, everyone. I'm also a consultant. I work at CEI CMH in Lansing, and I oversee what we call the Court and Community Liaison team here at CMH, and I'm very excited to see the number today. Welcome.
And our guest of honor.
Oh, you're talking to me. Okay. My name's Tom Kermani. I work for Michigan Municipal Risk Management Authority. So some of you know, most of you are members of MMRMA. Most of the CMHs in Michigan, both north and south of the bridge, are members. We basically insure municipalities, counties for liability and property. I'm a senior risk consultant. I've been there about 10 years. Prior to that, I was the administrator of the Livingston County Jail in Howell for about 13, 14 years. And before that, I was a police officer. I was a detective lieutenant with the Michigan State Police. And before that, I was a city police officer in a couple Detroit area police departments. So I've got a lot of experience in public safety, and like I say, we do a lot of work related to risk avoidance and risk mitigation, and we work with the lawyers that represent us and represent our clients in the event of any civil litigation.
Right. Well, to kind of get us started, Tom, I would love for you to share with us maybe the areas that most often present, at least in your experience, issues around liability. Like where are organizations maybe most often running into challenges with liability or related to liability?
So I can give you some general perspective. Is obviously, obviously we have um, we have what they call reinsurance reports. So we get reports on lawsuits, pending lawsuits, closed lawsuits, lawsuits that are taken to trial, lawsuits that are settled and stuff like that. We do not see a lot of exposures generally in CMHs. There are some. Obviously, there's professional exposure. If you're a licensed professional, obviously you have professional exposure there. But where the exposure lies sometimes is most most government employees and most CMHs are considered employees of a governmental entity. They enjoy a level of governmental immunity, with the exception of incidents of like what they call gross negligence. So if I'm a police officer and I respond to a person that's disturbed and he's clearly meets the criteria for evaluation and hospitalization, and I don't take action, they would call that could be considered gross negligence. And the same thing with a provider. If a provider ignores obvious symptoms and obvious information associated with the symptoms, and they don't act on it, there's potential for liability. Those are the ones that jump out at you. But there's other areas too. I mean, there's some stuff, and I know I provided Julia with some information. CMH can't be guardians, and I'm sure everybody knows this, but this is just something that our attorneys emphasize to us. CMH can't be guardians for people that have mental health issues. They can be guardians for those that have that are disabled, people that have disabilities and stuff, but not people that have been designated as a mental health patient, and that's obviously something that's addressed by law, and I'm sure everybody in your organizations are aware of this. Those are the things that kind of jump off. Now I can answer questions, but a lot of this is situational. Some things mistakes get made, and if mistakes get made and it's an honest mistake, that's not usually deemed gross negligence. So then you have an immunity issue that will come up, and most of the time you'll be given governmental immunity, and you'll be uh, basically excused from liability. So it's like those are the things that I do not see, and the attorneys do not see a lot of um, a lot of liability, uh, considering what you guys do with AOT. But I'm willing to answer specific questions about this. So
Interesting. Thanks for kind of sharing that perspective. And um, in my role as a professor, I know that this is something that a great number of students very often are asking about in class. They have this abiding fear that they'll make one little mistake and they're going to end up sued out of existence, or they're going to end up, serving prison time for something. And all I can do is draw from my 25-ish years of experience where uh, it's very rare to actually see something formally brought, except in those cases, like you mentioned, of such gross negligence that it's almost unavoidable that, something would happen. And in those cases, most of the time, what we see are individuals kind of seemingly going out of their way to do something that they really shouldn't. And I'd love to hear from you, Christy, based on your rich experience, what you've seen.
So I concur with both of you. I think that it really does come down to the honesty, the integrity, the intent. If you're doing everything possible that you can and you're not ignoring critical situations. So for those on AOT, if you're attempting to make contact, if you're communicating with the judge, if you're documenting all of your attempts, your liability risk goes down significantly. You have to operate with good faith. And I know that we deal with some really challenging consumers, and it feels as though the onus is on us, especially lately with NGRI cases and what have you. But I think the most important tool, and we learn this in school and it carries on, document, document, document. And when you have done your documentation and done a thorough job, sometimes that's all that you can do. We can't, unfortunately, predict and save everyone, but we certainly, doing our very best and reporting that. Like you said, we don't risk that gross negligence. So I think that that's really, really important. And communicating with other partners. If you're struggling to locate someone, say on an AOT, reaching out to those community partners, documenting that, having that communication, showing that you're trying and you have every effort out there. I think that that is a huge part of it.
So I want to highlight something what Christy just said. And I don't care if it's mental health arena or public safety, if you work in a jail or if you're a police officer, documentation is everything. If you're not documenting everything, that's what exposes you to liability. And what ends up happening if a lawsuit's if so an attorney, the process is kind of important too. If someone sees a weakness in the system, they're going to, an attorney, a plaintiff attorney, they're going to take advantage of it. And we have a lot of our lawsuits, we end up having to settle, or or we can't get them dismissed, even though there may be no basis for it because there's no documentation. Or what happens is they've got 3.5 years to file litigation, and the people involved don't remember it because they didn't make good enough notes, and they didn't document everything they should have documented. And paperwork is important. Supervision is another one of the biggest areas of liability. You got to have some oversight with all your processes, and that good practices and good oversight, because obviously what Christy just highlighted is there's all kinds of little mistakes that are made, but that doesn't make them liable. But they can try if they know that if they send out an FOI request for information that they do have ability to get. Obviously, they can't get a lot of patient information, but they can get maybe some of your notes, so they can get some of your records. And if stuff's not there, they'll take a chance taking to court, and then they'll get you in an area where they'll depose you. And if you don't have good records, they'll pick you apart. And is a lot of people think, oh yeah, I can outsmart the attorneys. You can't, because they can ask you anything, and they will come after you every which way from Sunday, and they'll videotape it, and they'll find ways of embarrassing you. You don't want to ever be put in that position. And I'm not trying to scare anybody, because generally, I know in your profession, you guys document way better than in my previous professions. I mean, police officers historically, depending on they think they're used to criminal investigations, so they document for criminal investigations. But there's a lot of little things, like something somebody said or something somebody did, a clenched fist and stuff. They don't put the right descriptors in their report, which gets them in trouble civilly, not always criminally. So those are things that I think you guys generally do better than a lot of other disciplines. So
I think many are encouraged to hear that, especially knowing that it it is still a never-ending process too, especially if you are supervising others, to make sure that not only are they completing their documentation in a timely manner, but that the documentation is actually proper as to like form and function. And something that I inadvertently started doing early in my career that worked out well for me in a court case, and I've continued to both practice this and teach others. I try as often as possible, especially when I'm assessing for some form of risk, danger to self, danger to others. I try to quote the client directly when possible, so I can actually let the client speak for themselves in the notes and give more insight into how I arrived at my decision. Because I know that when we think about areas where we might feel most exposed to liability, decisions we make around somebody who is experiencing some level of suicidal behavior or homicidal behavior, what we do next often is what really brings this issue kind of to the forefront of our mind. Like, I don't want to blow the call and harm somebody. I don't want to blow the call and expose myself to risk or my organization to risk. And I'm wondering, kind of in that vein, Tom, what are some other strategies, maybe along with documentation, or I'm thinking even in terms of uh, agency policies, procedures, what are some other best practices that we should make sure we're doing to kind of minimize our overall exposure to risk?
Well, documentation, storage of documentation, access to documentation is really vital. What you said, Scott, is really, really important. Is in a deposition, you may say, and I might just get back on your point. You may say something, well, the patient expressed X, but he said it differently, but my interpretation was this is what he was trying to say. I think you need to put down exactly what they're saying. It's just like what we train our police officers to do. Don't put down what you think they're saying. When you take a statement from somebody, we lose a lot of court cases because the police officers think that they know what the person's saying. Like on a criminal investigation, they'll put down what their perception of the message that the witness is trying to get across. But they need to put down exactly what the witness says, because again, those are things that you'll get hung up in court on, and you'll end up losing, and you'll end up getting in trouble. And I think training is huge. Training is huge, and everybody in our profession and your profession needs to have these same kind of standards. This is how stuff gets documented. This things that are said needs to be in the reports based on what is in your discipline, what you require for your reports. Because I'm not, obviously I'm not in your discipline, I really don't know, but we have standards, law enforcement standards, standards in correctional facilities. These are the kind of reports you have to write. And then supervisory oversights on the report. And the other thing that is just be, especially, and I don't know if there's a lot of supervisors on this Zoom meeting. Oversight is so important, because there's a lot there. I could tell you from like my perspective as a police officer, I've worked with mental health people a lot in all my jobs, and I was involved with crisis intervention team training with Dr. Pinels and at Health and Human Services. I rode with the Memphis PD after they developed the crisis intervention training. It's just like, I really have a passion for this. I started an opiate program, and we start having an explosion of opiate deaths, myself and one of our court administrators. And these things are really, really important to me. But the only way these are successful is if everybody follows the custom and practice and standards and adheres to them. And where some of us get in trouble in our business, and Scott, you can speak to your business, but there's people in your business and in our business that I've run across that may or may not be really ideally suited uh, to perform the functions that you're required to do, and it's hard to it's hard to supervise. It's hard to get rid of people that really shouldn't be in the profession, and that's where we get in trouble. Just no matter what discipline. I mean, we've got bad police officers, or I should say bad. We have police officers that probably shouldn't be police officers, and there's people in your profession that probably shouldn't be in your profession. The other thing I want to touch on really quick is there's a lot of confusion out there licensing. So we have people that practice treat mental health clients in our jails that I don't think are qualified, and nor do our attorneys. There's so many different types of licensing out there, and we get confused. The attorneys get confused as to who can provide what services and what kind of arena. And these are things that kind of get us in trouble because we'll have vendors that we hire that are hired by our members. Most of them are from out state, and they'll provide like medical services and mental health services, but they'll have a BSW doing medical assessments on suicide watch or different things. And and in our business, we don't think they're qualified to do it. It's just like we don't want any LPNs working in any of our correctional facilities. And 10 years ago, that's all that was working in correctional facilities is LPNs. They're not trained and licensed for diagnostics. And so, why would you have them in a high risk environment like that? So, and I know I'm elaborating a lot, but I think you guys know exactly what I'm talking about. There's people that work outside the scope of their education and license.
Yeah, I think you raise a point that we can all very strongly resonate with. And, you know, I always feel a degree of responsibility as a professor of social work to be kind of a guardian where possible of the profession. But I know even in my clinical roles, sometimes it's really hard to have to say to somebody, you definitely have a passion for helping people, and I want to help you find where that is. But the only thing I know for sure is it's not here, it's not in this role. And one danger that I've seen actually in uh, 5 different states that I've worked in some capacity is very often our approach with these individuals when they're clinicians that we don't sense are appropriate for the job is we tend to try to move them into other roles because we don't want to just make the hard decision and say, we got to help you find the right place in life. And regrettably, I think this really causes a lot of organizational failures. We see people now in often even supervisory roles who, frankly, weren't a good fit in that direct client facing role, and now they're overseeing people who are. And I'm just wondering, is that a problem you see from your end of things? And if you do you see it more in the mental health world, or do you see this actually extended into uh, different domains where you provide risk management?
So we see it more in the mental health role. And again, I think there's a lot of people with a lot of good intentions, but unfortunately, these companies are competitive, and the cost of care, especially like in our correctional facilities, the cost of care is very, very high, and especially correctional care. No, it's not a desirable place to work for a lot of people, and so they'll bring people in that are young, inexperienced, eager to learn, but they're jail inmates easily manipulate staff. That's all they do. They have nothing but time on their hands. They find ways of manipulating staff. It's very easy to manipulate a young, naive person out of college that really wants to help somebody, and someone will take advantage of someone's naivety and put them in an awkward position, and not anything criminal, but just in awkward positions. And the practitioner sometimes will advocate for a specific patient, and that creates a lot of problems for the security staff. And the so we do see that quite a bit. And so you'll find you'll find there's a lot of turnover in these jobs in facilities. Now, where they work best, I can only speak from, getting around the state of Michigan. What I've seen is where they work best is if they come from, if you have an arrangement with your local community mental health and you bring their people in and they rotate people in and out from time to time and provide those services, because then they work out in the public sphere and not just in the correctional sphere too. So, but they provide like a level of service. They'll do suicide assessments, and then they'll treat their customers, consumers and that are incarcerated in our facilities, and they'll provide training for our staff too. Is we have saturated the state with training on mental health diversion, uh, symptoms of both behavioral health and developmental disabilities. So 10 years ago, I'd say there was very few people that really kind of understood what a closed head injury looks like. Someone with PTSD, someone with schizophrenia or whatever like that. Now it's much, much better. It's much, much better. The training's better, and I think the collaboration's better. So I've always been really close to people in the mental health arena, and we put on a training. This is just anecdotal, but we put on a training up in the Bay City area, and we had police officers and police administrators and mental health professionals, and we in the mental health PhD that was there said, let's do this. Allow them to sit wherever they want in this auditorium. And on one side of the room, that's where all the mental health professionals sat, and all the police officers all congregated the other side of the room. And the doctor basically mixed them all together. And then we talked to them about this and the level of discomfort was astounding. I mean, the mental health people didn't trust the cops. They didn't want to be around the cops and stuff. So it was just that I think that's gotten a lot better too. I think we have to work collaboratively to take care of these people, and I think you'll see. I think for the most part, police officers are moving in that direction. Although there's some outliers out there, but it's a lot different than what it was when I first got in the business. So. I mean, I don't know what you guys see in your community, but we're not. Um, we have some bad apples, but we're trying hard uh, to follow the best practices of treating people with mental health disorders or people in crisis as best we can. So.
I think most of us are also benefiting from seeing a lot of that improvement and the improved uh, inter-organizational, workings, which actually brings us to like a few questions that generally fall under this broad topic of how maybe risk and liability extend from us in the CMH world to the other entities that we routinely have to interact with, whether it be law enforcement, emergency departments, and vice versa. So in instances, let's say, where we determine a client is not adherent to treatment and they're on a court order, we reach out to have law enforcement transport, and they transport to an ER. Sometimes law enforcement can't or doesn't, for some reason, fulfill that transport order. Does that fall back onto us as the CMH in terms of like the liability?
No. So if you want to document that, so this is a problem. There's a staffing shortage, a major staffing shortage for law enforcement officers, for correction officers, all over the state and all over the country. The pay is getting better, but look, depending on the region you work in, I mean, it just depends. Every facility, every jail facility, with the exception out of we have 83 counties. We have only 79 operational jails. The other counties lease beds from other jails, and almost all of them, with the exception of 4 or 5, are short-staffed. So, and what happens is staff is working mandatory overtime, and there's a mental health crisis with the employees in the jails because they're being overworked and they're underpaid, and there's no relief in sight because people don't want these jobs. And a lot of it is the political climate. I mean, their police officers are looked at differently now than they were maybe 20 years ago. So it's just there's not a lot of there's a lot of unanswered questions and a lot of unsolved problems in hiring and retention and stuff. So there the liability would fall on the agency if they're required to do it. So what happens is like there are if you get a court order, if you get a court order from a judge, the sheriff's department is has the responsibility of that court order. So when a judge issues an order from the bench for someone to transport, usually the sheriff's department, or they can order the local police department. If it's like the city of Grand Rapids, they can order the police department to transport them to a hospital. But absent that, unless you have a good relationship with the administration and your police departments and stuff like that, they may tell you they're too busy or they're short staffed or whatever. But uh, relationships mean so much. I can tell you in the areas I've worked at around Michigan, if the CMH people had a good relationship with the local departments, and I think that that worked that worked so much better. And those things happen. But as far as the liability, you would have no liability as long as you documented it. Of course, the expectation is you'd find another way of getting the patient to where they needed to go. But that's just, to me, negligence when if you've got someone that needs to be evaluated and you don't transport them. So
Yeah, so I just wanted to concur with that. I think that what he's pointed out is huge. It's those relationships. And when you look at liability, that is a big part of it, is having those working relationships with the community partners. Because when you do have that, you both are taking, of course, on that liability and you're working together and having a form of communication. For us, what we have is to keep them accountable because, like you said, they're busy too, right? They're understaffed. We're all understaffed. So like for us, we have one line of communication. It's like a police envelope. And so the documentation occurs there. It keeps people honest too, like how many attempts have you made? What's been done? And reporting that back to the judge. But it really is that team effort. Oftentimes in these larger jurisdictions, you drop off a pickup order. That's not their priority, right? Officers are trained to, address crime, and picking a mental health consumer up isn't theirs. And so it really is that, and it's so much training. I think that that's huge, is that we have people out there, like you said, that aren't trained, and same as officers. And we just talked about this morning too, the risk mitigation and that, and understanding the risk and getting people out there trained. I think that's huge. So it's our documentation, it's our training, and our relationships. And then together you take that liability on, right? Another thing that I find really important, and I don't know that we'll address this today, but honestly, working with your staff too on being present in court and what that looks like too. So many of our staff have not been to a court hearing. They don't know how to address a judge. They don't know how to address an attorney. What's allowed, what's admissible in court. They often will give you a judge or the attorney will ask a question, and often you find someone telling the whole life story. No, 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 no. Very clear, concise answers. Don't give more than they ask. And so it's some of those basics that they're not getting, which I think also increases the liability out there too. So as supervisors, really working with your staff, if they're going to have to go before the court, doing mock interviews, having these things, having them prepared clinically, making sure they're getting with the recipient rights advisor. All these things can cut down on the liability. So I just wanted to add that piece.
yeah, she's right. She's right on point. She's right on point. One of the things, and this is so this is just an illustration, is forever, for years, you would hear, because, I was a boss for a lot of my career, and someone would say, yeah, God damn it, CMH is calling me to pick up this guy. Well, obviously there's rules and use of force when you're picking up when you're arresting someone. There's the force you can use, obviously, to take the person into custody. But when you're picking up a patient and you're taking them to a treatment facility and they get aggressive, and then and the police officers are just as worried as everybody else. Well, I don't want to deal with this, because if the guy fights with me and I end up hurting him, I might get charged. And so there's a built-in reluctance. That's point one. Point two, and in the communication piece is so important. You got to have a contact at every level. You need to be able to, you have to have meetings, if you can, with the administrators of the whatever department, or whatever police departments work in the communities that you serve. Because what ends up happening is there's a distrust, and some of the distrust is very unfair. And this, I know everybody's dealt with this, is police officers will say, well, tell me about this person. Well, no, you can't disclose it. It's patient client, it's confidential. Well, as soon as you should do that to a police officer, most of them are going to say, well, screw them. I don't want to deal with this. That's the reality. That should not be the reality, but that's one of the realities. They get very frustrated. Even when I was a jail administrator, I would have community mental health, and I'd have one of their consumers in custody that was on a psychotropic med that wasn't that we didn't have in stock. And I would call CMH, and CMH would say, well, I can't share that information with you. I go, well, wait a minute, you expect me to treat them, but you're not going to let me see their medical records to see if they are actually on these meds. It's just like, everybody says, oh, I'm on Seroquel or whatever. Well, how do I verify you're on Seroquel? Because CMH, who they get their Seroquel through a CMH provider, they don't share the information. So again, there's got to be good communication, and there can't be breakdowns in that communication, because when there are, bad events get amplified, and then that gets toxic. And I'm sure a lot of you that are practicing out there in the communities have seen that. If somebody has a bad hiccup with a police officer, that gets amplified. If someone gets a bad hiccup with a provider at one of the CMH offices, that gets amplified too. So that's stuff that you really need to work on. Now, that's not necessarily a liability issue, but that's an operational necessity. And I think most of you probably have experienced that. And I'm just telling you this because this is stuff that we see quite often. So
That's, I think, a really important point, and reflects a few questions that had come up prior to the session, really about um, liability when it comes to those situations where we actually do have the ability to disclose or share information because it's part of continuity of care, or the client is in an emergency situation, or law enforcement is performing a specific service on behalf of the mental health system. HIPAA actually has explicit, provisions to allow this communication. And yet I think what's regrettably happened is more people have just embraced the idea of, like, we can't ever share information. And they've done this from the standpoint of, well, this lowers my risk, when in fact it actually exposes them to more risk, because they can do something and they're failing to act. And, I had a similar situation happen not too long ago. I have worked as a reserve police officer. I actually work with somebody you might know, a retired Michigan State Police Captain, Harold Love. And we do a lot of critical incident debriefings for first responders after a traumatic on-the-job event. And we had an officer that was executing a pickup order, and only was getting information from the family, who failed to mention a history of violence, failed to mention a traumatic brain injury in addition to a few other diagnoses. And the officer ended up being very seriously injured. And what struck me was that everybody lost in that situation. Trust was broken between, the law enforcement and mental health team. There was obviously one individual very seriously injured and another individual now facing very serious charges. And all of that may have been mitigated by, better sharing of information to coordinate this care. And I'm wondering if you can maybe give us some guidelines on how to um, stay within our legal limits, but make sure we're doing what is in our client's best interest in terms of sharing protected health information.
Well, I will tell you this is one of the things the example you cited has happened multiple times, where information's not disclosed and someone will get hurt. And again, this gets in the community, and then you know how things go. People start talking about it, and it gets embellished and repeated over and over and over. So basically, CMH people get vilified unnecessarily. Now, somebody may again, I I think the rules have to be. I think people have to be trained. The policies have to be in place where this is the stuff you can share. Police officers need to know if someone's violent. They need to know what kind of medication they're on, if they're on their meds or if they're off their meds. If you're going to pick up a schizophrenic that's been off their meds, that's got a history of violence or whatever, the police officer needs to know that, because it's just like, you don't want them to you don't want them to get hurt, but you don't want them to have to hurt the patient or the consumer. It's just like that. And that's where CMH can get sued. If CMH fails to disclose stuff, if you fail to disclose stuff and you got a pickup order and you want somebody picked up, and you fail to disclose information that is crucial for that officer to know, and something bad happens, there's potential for liability. And I'm not saying that there would be, but there's a potential there, because I mean, I can see a claim being made, because you're basically, you put the officer in danger by not disclosing the information that you had on hand that did not fall under a protected status. Because like I say, with HIPAA, it's like in a jail. Correct. There's an exemption for corrections, obviously, because all the medical and mental health training, that once someone is incarcerated, it's the jail's responsibility to provide care. Obviously, the level of care is different, but there's a responsibility to provide care. All that information needs to be shared with the jail, because they have to treat this person that is no longer able to enjoy the benefits of the CMH, that CMH offers. Obviously, they're subject to the level of correctional care that is being paid for by the county. So those things, and I don't think a lot. I don't think, and again, I'm just telling you from my experience. I don't think that is emphasized enough to the people that provide service all the time. But to me, that's a management issue. And that's where the exposure is. It's a management issue. Management needs to make sure everybody understands that.
And I'd like to kind of add to that, because I think we often see that coming from a CMH perspective, the recipient rights, and we're, over and over, HIPAA, HIPAA, HIPAA. And so clinicians, that's the number one thing, right? But it comes down to that risk benefit, and you really, as clinicians, have to be mindful. And when I'm working with people, I say, it's very important that you share that information. You do not need to share the consumer's deep, dark secrets, but you do need to be able to provide information to officers, the emergency room, whoever, on health and safety. You need to let them know, like, do they often carry weapons? Do these things? Because absolutely, it is so critical, and we want to have good partnerships, and we want to do what's right out in the community and bring groups together so that for the benefit of our consumers. But if you leave out critical information and people get hurt, I always tell people, I'd rather get my name in the newspaper for being sued because I told them that the consumer I'm working with, is schizophrenic and they often carry weapons and these are the things, than not saying a word. So it's really, like you said, comes back to that supervision and that training and understanding what is okay. And think about it think about it from the officer, the ER's perspective. If as a clinician, maybe making a home visit, what would you want to know about the consumer before you went to their door? That's the stuff that the officers, that's the stuff that EMS need to know. And it's okay. And you document it based on health and safety of the situation. This information was disclosed. And I think we're getting away from that. And I hear it every day. Well, I can't tell them. Well, then how do you expect them to help you? And so I know often agencies, their recipient rights are on you. And I just say, be honest. If you're making a good faith decision ethically to do what you believe is right, that's what you need to do. And so I know that that's hard for clinicians. So really weighing that out. And yes, you can share this information.
That's point well taken. And I just think that, most of the time we see it with young clinicians that are maybe right out of college, because I don't know what they're teaching in the universities, but I think it's just like they do in the police academy. They get you so paranoid. Well, they didn't when I came in. I mean, basically, no one ever worried about getting sued or getting charged with crimes. But nowadays, there's so much emphasis on, well, you can get sued for this, you can get sued for this, you can get sued for this. No one wants to do anything. That's why there's no such thing as they used to have proactive policing. Proactive policing is one of the biggest components to reducing crime in the country, and there is no proactive policing anywhere in the country anymore. Proactive policing is where you go out and you look for people and you look for situations where someone might have a gun in their car, where they may be on the way to rob a dope house and stuff. They're not going to stop. They don't stop cars like that anymore, because if someone complains, you're under a microscope. So you're better off just looking the other way. I had an attorney tell me, and this happens. She was in Greektown, and she watched a gunfight ensue, and there's two Detroit police officers sitting down the street watching it. And she went over there. She was, "Are you going to do anything?" No. They go, "No," because if we do, and we have to shoot somebody, we're going to jail. And that's unfortunately that's kind of the climate, the world we're living in. So you on both ends, you've got mental health people, practitioners are maybe a little paranoid about releasing it, but you have police officers on the other end of the spectrum. They're scared to do anything right now. I mean, they're scared to do anything. And even though it's a small number of police officers that get charged, it's out there, the media amplifies it, and people are scared. And but I think there is liability. What you said, Chris, right on point, right on point. And I think that needs to be uh, applied in every CMH around the state. I mean, everybody needs to practice what you just mentioned.
So, yeah, thank you so much for your insightful words. So, Mac's question was, can there be a liability on CMH following a judge's decision? For example, questionable release from a hospitalization?
And let me elaborate on this one and this will bear no intentional resemblance to anything that may or may not have happened. But in a situation where a judge basically compels a facility to not follow normal best practices or Centers for Medicaid, Medicare rules in terms of a safe discharge, but just orders the person be immediately released without any of the normal planning and discharge prep that is required to be done. Does that judge's order indemnify essentially the hospital, the organization that complied with the order? Does that shield them from any liability experienced related to a poor discharge?
So judges have absolute immunity. So having said that, is as long as you, first off, we talked about, as long as you document it, one of the things you need to do, and we tell all our police officers to do, when you get an order from the bench, judges sometimes just do whatever they want to do. And the order may even be unlawful at some level. But if it's something that's going to expose you or your staff to liability, you need to have a communication, ask for a show cause hearing, or ask for reconsideration. Get a hold of your prosecutor right away, or get a hold of someone in your community that at least you got to at least make a little bit of an effort, because if you comply with something you knowingly know is wrong, uh, that I think, again, it's a judge's order. You have to follow a judge's order, but you want to make sure you've covered your own back and say, well, because they're going to ask you, why didn't you ask for a show cause hearing for reconsideration, or why didn't you do this or that? And again, usually your local prosecutors in the counties you work at will help you with those kind of situations. Those are emergent situations, and they can help you. And even like I say, I can tell you from where I sat as a jail administrator. I can't tell you how many times the judge threatened to put me in jail because I would walk over. I'd have somebody like you, Scott, call and say, "Hey, the judge just issued this order." I'd walk over and go see the judge right then and there. If you've got that relationship, and say, "Hey, judge, you can't do this," and a lot of times they will change their mind because they're listening to a buddy they went to law school with, or someone that's advocating for this client. A lot of times they're only getting partial information, and a lot of times they'll change their mind. Sometimes they won't. But if you made that effort to try and change your mind, I think you're in a good footing.
Wonderful. Thank you. Thank you. Yeah. We had another question in the chat from Stephanie, who asks, what do you do when the police will not pick someone up even if they are being disruptive, dangerous, etc., without a pickup order? But you cannot get a pickup order because the court does not have a copy of the stipulation or deferral in order to complete the pickup order.
So obviously that's situational. If the person's being disruptive, if are they being disruptive in a home? Are they being disruptive in a public place where you can charge them with disorderly conduct? If there's something where they can get dispatched, or if it's a domestic family issue and they are being disruptive, are they breaking stuff at the house? Because that's part of the domestic violence law. Obviously the officers have a responsibility to take action in those cases. And when they don't, they have all the liability. So they are responsible. Like I say, they are responsible to make sure no one's getting hurt. And again, this is I would go over. If Central Dispatch said we're not sending anybody, say I want to talk to a supervisor and document it, and insist that somebody be sent out, because if they hurt somebody, it you guys have done your job. You don't have any liability, but they have a ton of liability if they don't act on information like that, because these situations can the consequences can be terrible. Someone's out of control or disruptive, or agitated and stuff. You don't want to let that set.
We've had this situation occur a lot with one particular police department. They absolutely will not take somebody. We've had our crisis team. They go out with the police on a regular basis. We have a crisis negotiating team as well. And they will go out to the usually apartment complexes, things like that. I can think of a recent situation where the person was literally, you could see flooding coming from the apartment. He was throwing things out the window. He was losing it, and they wouldn't pick him up. They literally wouldn't take him out of the apartment. They won't touch him unless a pickup order is in place. And so this has gone on in certain situations for days, where the crisis team continuously gets called back but can't do anything, and just idly sits by while he destroys his apartment, and nothing can be done about it.
That sounds like a serious management flaw.
Mm-hmm.
Which
What's
agency?
that?
Okay, do you mind sharing the agency?
Sure, no problem. Police department.
Uh, yeah, that's very troubling.
I'm
That's
going to
very
be
troubling.
devil's advocate for a minute though, because I'm hearing a few things. So they don't have a judge's order. And so we run into this, I hear it, Stephanie, like we deal with this every day
Mhm.
here in Lansing too. Officers are very concerned about taking someone into protective custody without a type of order, because when that escalates and they don't have an order, they're scared. So my question is, what is holding up from, like, if your crisis team is going out, them going before the judge and getting a pickup order, and then the police have to pick them up. And then you said deferral, and then you said stipulation. So I'm just trying to get a clear cut and, like,
Okay.
is it, yeah,
So, for instance, we had a situation, Stacy can jump in if she wants, where we waited, I want to say it was 7 to 10 days to get a pickup order last week because there was no stipulation from back in May that
Okay.
was put into the record. In fact, we had a conversation with a lawyer today saying, I don't know where that paperwork is. I'll do anything I can to fix it. But it's, it's November almost. So, we weren't able to get that. And so in the meantime, we keep expressing the dangerousness, the liability, all of the concerns that we have, but the police department will not pick somebody up unless there is an absolute order signed, sealed, raised seal, everything by the judge. They will not pick somebody up. The problem with the crisis team is that some of these are happening after hours.
yeah.
And so this is the middle of the night and these people are being disruptive. And so again, they'll call the mental health people out to assist with them being unable to do anything. All of their recommendations, all of their assistance is useless when they won't pick them up, even if they're criminally damaging things and threatening people. Unless there's a pickup order, they won't pick them up.
I think that's too where you build it's those relationships, and like he said, maybe taking it higher, asking for a supervisor, also bringing your judges into this too, so that they can collaboratively maybe
Yeah.
meet with the police. I mean,
I would love that. I would love that. I've been here for 32 years at CMH and we have never been able to build that relationship with the police department to change in any way, shape or form.
that's hard.
And getting a meeting with my judge becomes my lifetime mission at this point.
Oh, I'm sorry. I mean, those are, yeah, because that's where, that's where it comes from, because you're gonna have those police departments that are sticky, and those after hours things are so difficult, but that is the hesitancy that we are seeing out there, so.
So the law, again, and again, it just, everything's situational. And Stephanie, if someone calls in that someone's being disruptive or threatening assault or something in a domestic situation, if they're at a house, the law the law allows the police officer to arrest on probable cause that, if he's damaged something or if he's assaulted somebody or threatened to assault somebody, they can take action. They can remove this person from the house. This now obviously what muddies the water if it's mentioned, well, we want a court order for pickup for evaluation because he's mentally ill. He's going to have to be treated. He's going to have to go into the criminal system for the police to take action on it. And I think once you get in that, once that happens, then I think CMH can obviously take action, because what's going to happen? They're going to do a diversion if it's a first time offense and stuff, if they know he's on medication or if they know if he's one of your consumers or something. But I think it's another roundabout way of getting this person removed from the house. Now I know they will act on DV because they have to. The problem in county is the prosecutor is very reluctant to charge. He doesn't. They don't. The charge. The current prosecutor does not like to charge people in these kind of situations, and I know this from experience. Every community elects a prosecutor, county prosecutor. This current prosecutor and the police officers know this, so they don't want to. I think they don't want to arrest somebody they know the prosecutor's not going to charge. And then again, that's one of the communities that I think is probably police officers are more worried about being charged criminally or civilly sued than a lot of others. Now, if you're in again, it's a community, and that's what the community expectations, and that's what they elect is someone like the current prosecutor, and that's what they want for their community. But because of that, there's going to be things like this that fall through the cracks. So, and there's no way of fixing it really. So, but if they call it in as a domestic, the police officer has to take action.
Great. Thank you all so much for sharing and sharing your questions. I see that we're a little bit over, so sorry about that, but thank you so much for contributing to this fruitful discussion. And if there's any, thoughts or questions you have after the fact, my email's in the chat. Feel free to email me. And yeah, happy Friday and have a great rest of your weekend.